Okay, good morning, everyone. Good morning. And thank you all for coming. This is the first of 5 joint programs that Achieva Family Trust is doing with Heffron Tillotson in regards to future planning and financial planning.
Thank you. Why would you need to do?
All of these programs are made possible through a grant that we received from the Foundation for Financial Planning. And while this generous grant enabled us to host these programs, we were in search of a partner to help present the financial side of things, and we found a wonderful partner in Heffron Tillotson. Darren Hucko, who you will be hearing from in a little while, has been very helpful to us in developing the format for these educational sessions, and we are extremely grateful to project. In addition to Darren, you'll also be hearing from Jackie Connell, our attorney, who will provide you with valuable information in regards to special needs trusts. But first I want to introduce Maria Smith, who will be talking about government benefits and reasons why it's important for families of individuals with disabilities to plan for the future. Maria is our Director of Education and Outreach at Achieva Family Trust. And again, thank you all for attending today, either live here at our office on the South Side, and also to those who are online for the webinar. Thank you.
Thank you, Amy. Just a couple of housekeeping items. Thank you. The bathrooms, for those of you who aren't familiar, are in the middle corridor. You can go out either door. Also, just to let you know, as Amy said, we do have a series of these presentations. There are about 5 family meetings that will be taking place around the Pittsburgh area. So I encourage you, we have the flyer on the front table. So if you have family or friends that live in these other areas that may want to attend, I encourage you to share that information with them. And today, some of you may have heard our presentations before on future planning. We've been doing future planning now for quite a while via our grant through the United Way. And so today we'll give a little bit of an overview or recounting of what future planning entails, but the focus today really is on the financial aspects. It's the area that we really haven't covered, in terms of our past presentations. We focused on legal and some of the service aspects, but not so much financial. So we're happy to have Darren today to talk about the financial aspects of future planning. Just again, for those of you that aren't familiar, again, let me just go, just again, for those of you not familiar with the Achieva Family Trust, again, we're part of the Achieva family, and again, we're formerly ARC Allegheny, and again, our roots were a grassroots organization that was started by parents in the 50s out of concern for their children with disabilities. Achieva is one of the largest providers of services to individuals with disabilities in southwestern Pennsylvania. And again, we provide services through the lifespan, again, from early intervention, residential services, in-home services, employment services, and services for older adults and advocacy. Achieva Family Trust was established in 1998 in response to some changes to Social Security law that established the creation of a pooled trust. And when Jackie talks a little bit about what pooled trusts are, you'll see that the Family Trust, we are a nonprofit organization, and the pooled trust requires that the trustee be a nonprofit. And we were actually the first organization, nonprofit in Pennsylvania, to offer and create the opportunity for people to have a pooled trust. We've grown over the years since 1998. We now have over 2,200 accounts, And we do serve people across the state of Pennsylvania with all disabilities and actually 12 other states. And we currently have, that says $110 million, it's more like $115 million under management. Back in 2014, actually back in 2012, one of the things, our history with the Family Trust, we've always been meeting with families and talking about future planning, and that what is going to happen to my family member when I'm no longer able to care for them, and how do I plan properly, what are the things I need to do to make sure that my family member has a secure future. So our history is that we've always done that work with families at no cost. But back in 2012, the United Way had done a survey of caregivers. It was actually as a result of a very unfortunate situation with a father who had taken his own life and those of his son because he was concerned about the future of his son now that his wife had passed. And so that was a call to action for United Way, and they did a survey of caregivers looking at do those caregivers have a plan in place, and found out that fewer than half of the respondents actually had a will or any kind of plan in place for their family member when they can no longer provide for their care. So the United Way put out a request for proposals, and it was a natural that the Family Trust applied for it. And in 2014, we were awarded a 3-year grant to do education and outreach, just like the kinds of things we're doing with this program, to provide families and service providers, by the way, and attorneys and financial planners with the tools, the information to know what are the things that a family member needs to consider to plan properly for their family member with a disability. And the Future Planning Project has been tremendous in terms of allowing for us to, again, have staff. We've always known that there was a need, but the grant from the United Way has allowed us to have staff to actually go out and carry out the education and outreach for caregivers and support. We also are collaborating quite a bit with the legal profession in terms of trying to foster and facilitate competent legal services. It's a very specialized area of the law, and so that to the extent we can identify for families who are the lawyers that are out there that have this kind of expertise, it's one of the things that we have really done a lot of as part of the Future Planning Project. We have a future planning guide that is available also online for families that can be used to record information about their family member that they can then pass on to a future caregiver. And the whole idea is it allows you to explain the kind of information you would want to pass on, the health records, the information about their particular likes, dislikes, and it's 110 pages, by the way, and but you can get it online, but also it's available if you need us to send you a copy. Patty Arena, who's our coordinator of our activities in the back, can provide you with a copy. Again, the questions that usually families ask us when they come in to see us or they're contemplating future planning, it's things like what will happen if I suddenly become unable to provide for my family member? Where is my family member going to live? And how will my family member function in the community without me? And who will look after my family's finances? And who will make sure my family member's health care needs are met? And then also, when should I start future planning? And we always say it's never too early to start future planning. The idea is that over time, again, situations change, and starting early is always a good thing. Some of the things to consider when you're thinking about a future plan and as a family member, the government benefits that are available to your family member. Again, generally for an individual with a lifelong disability, at some point or other in their life they're going to be needing and accessing some type of government benefits. And I will touch very briefly on those types, the two types of government benefits to be aware of. The other things to consider are things like special needs trust, which again Jackie will talk about, which really help to provide a mechanism for preserving assets for a family member that don't interrupt government benefits. And then other things like future planning tools, letter of intent that sometimes families will be able to, the letter of intent, which is a kind of a document that sometimes attorneys ask families to fill out, which really explain the wishes of the family for the future for their family member. We mentioned about the planning guide as a tool, and then also the issues of decision-making, guardianship versus power of attorney. It's another whole area of considerations for families. When you think about your family member and their ability to make a decision for themselves, it's how do I, maybe you're in a situation now that you're currently assisting your family member with decision-making, or maybe you're their guardian already. The question is, how does that decision-making carry on in the future? So those are just some of the kinds of things to consider, but, and I'll just touch on, again, the government benefits just from the standpoint of making the distinction that you need to make in terms of needs-based benefits and entitlements. And again, why is this important? It's important because, particularly when we're talking about needs-based benefits, those are the benefits that really have, when an individual has income or assets in their name, it can really affect their eligibility for government benefits. So it's important to understand the distinction. It's amazing how many families that we talk to that, you know, when they call in and we ask them about government benefits, they're not really sure, you know, is it SSI, supplemental security income, or is it Social Security disability? And there are differences. And again, I will touch on this. I must say the government benefits area, this could be a whole session in itself. So I just encourage you, in terms of more in-depth information, you know, we do have some archived webinars that really go in-depth in terms of Medicaid and Medicare and Social Security. So, but again, important to understand the needs-based benefits, SSI, supplemental security income, Medicaid, and Medicaid waiver benefits. And again, those are the benefits that, in fact, do have certain income and asset limits, as opposed to those benefits that are termed entitlements. And those are Social Security disability income, Social Security survivors benefits, and Medicare. So, again, just a little bit about SSI. Many of you may be familiar. It is provided, it's a cash benefit that's provided through the Social Security Administration. And it's really meant to be a program that is provided for people with disabilities, people over 65, and also people that may have very little work history or maybe no work history at all in their lifetime. So SSI is meant to be kind of, we think of it as a poverty program that is really meant to allow individuals with disabilities and elderly to have kind of a minimum level of benefit for their needs. And again, but again, the level is the income, the monthly benefit, the max is $750 a month. There are income limits so that if you're receiving income from other sources, it can affect your SSI. And also, there's an asset limit, which means that they look at the funds that you have in your name, and that includes all of your bank accounts, the stocks, bonds, anything that's in your name, as well as cash value of life insurance and other assets that you might have. And if you have over $2,000, it can disqualify you from SSI. So again, it's an important, if your family member is receiving SSI or needs SSI, you have to be aware that the rules of that govern those that benefit are pretty strict in terms of income and assets. Tied to SSI in terms of the needs-based benefit or Medicaid. And again, most of us have, I think probably if you're working in the field or you have a family member of disability, you know how important Medicaid is. And it's the health benefits. It's the benefit that provides the health care, medical care, but also long-term care, potentially long-term care services for people with disabilities and folks of low income. Again, it's a needs-based program. It has certain income, just like SSI, has certain income and asset limits. And generally, the asset limits for Medicaid are $2,000, again, in your name. There are some other programs, like Medicaid waiver, that, in fact, has some higher asset limits. But in general, you have to be aware there are income and asset limits for Medicaid. It's a very important benefit for people with disabilities because it does cover medical and prescription services, which can be really costly. You know, for some of our folks that have complicated medical conditions or needs, it can be just very vital that they get that. The waiver services, which again are covering long-term care as far as people needing services in home and community, to the extent that there are Medicaid provides in-home therapy and in-home care, Medicaid waiver is an important service. And again, it can provide residential, attendant care, respite daycare, and a lot of other therapies through Medicaid. Hard to get, you know, when you think about it, Medicaid is that benefit that it is very difficult to get those services through private insurance, and even through Medicare, you don't get, you know, the kind of coverage that Medicaid provides. So it's a very important benefit to have. Once again, important to understand the distinction, Medicaid, SSI being those entitlements. Social Security disability, however, I'll go on, is what we call an entitlement benefit. And what that means is if you have worked and you have paid in, you know, just like all of us are working and paying into Social Security, to the extent we become disabled or we're ready for retirement, based on what we earned as a worker, you are entitled to Social Security benefits upon your either disability or retirement. It's strictly based, again, on work history, and again, it has certain income limits. The extent of the coverage is based on the wage earners' contributions and the number of dependents, and it is linked to Medicare. Again, why is Social Security important as an entitlement, particularly for, and we encounter this a lot, you may know this, specifically for a number of the people we work with who were disabled before the age of 22, an individual who has a disability before the age of 22 potentially also can be eligible for Social Security benefits on a parent's work history if that parent becomes disabled themselves or they retire or they're deceased. And it's an important benefit to know about because a lot of times the Social Security disability benefits for an adult disabled child can be above what SSI normally provides. Not only that, the other thing that it does is it also, if an individual receives that Social Security disability benefit, it's really not affected by any outside income. It's not subject to income limits unless the person goes to work full-time. So it's a kind of benefit we call entitlement, not needs-based. Social Security disability is tied to Medicare. Again, a lot of the individuals we work with do receive Medicare. They're not 65, but if they've been on Social Security disability for over 2 years, they're entitled to Medicare. And again, it's a benefit does provide medical care, but it's limited. Again, many of you are aware that Medicare is limited in terms of limited prescription and medical coverage, and normally people need supplements to Medicare in order to to provide for all of their medical care. So why, again, the distinctions that in these government benefits important to understand, because if you're thinking you're a family member and you're thinking about leaving assets to a family member, you need to be aware of what government benefits your family member might be on, and to the extent you need to think about protecting government benefits because your family member will need those means-tested benefits, particularly the SSI or Medicaid, then you need to be thinking about the ways that you can provide for them appropriately. And I'm going to turn it over to Jackie, who's going to talk a little bit about how to protect assets and some other things to consider.
All right, thank you, Maria. So I'm going to just start out talking a little bit about options to avoid in terms of future planning. I think some of these strategies are still often considered but a bit outdated, but just some of the things you want to consider to avoid when talking about a future plan. The first one would be disinheritance. Sometimes families think, I will just disinherit my loved one with a disability. I'll leave money to maybe that person's siblings or other relatives. They'll take care of my disabled child, my disabled relative. But it's important to realize some of the risks associated with that. Number one, of course, we hope, that our family members will always have the best intentions for our disabled loved one. But the fact is, if you're leaving money to someone other than the disabled person, there's no guarantee that they will, in fact, care for the person for that person's lifetime. But more importantly, if, say, the non-disabled child gets divorced or has a bankruptcy proceeding or has some kind of litigation against them, those assets could become in jeopardy. It is possible that there won't be any assets left. So it's really not a smart decision to leave money to a non-disabled relative in hopes that they'll take care of the person because, again, there are circumstances that could happen that are out of your control. The other tactic to avoid would be asset transfers. In Pennsylvania, depending upon the age of the individual, there could be a 36 to 60-month look-back period. What that basically means is that an individual can't give money away to another relative or someone else as a means of getting the money out of their name. That will be looked at as a transfer for less than fair market value, and the money will basically effectively looked at as belonging to the individual. So, again, asset transfers, we're not going to try to give money away as a means of getting money out of the name of an individual with a disability. And again, neither one of these options are necessary because special needs trust exists, ABLE accounts exist, and these are better options to funnel money to an individual with a disability. So, as Maria said, the primary purpose of special needs planning and special needs trust would be to, protect the government benefits of an individual with a disability, whether it's the SSI, the Medicaid component, waiver. It's really important that always remember that an individual that are on one of those means-tested government benefits cannot have substantial assets in their name. So we're looking to shelter those assets in forms of a special needs trust or an ABLE account so that they're still eligible for those benefits but have supplemental money to use for their care. So as I mentioned, there are a couple options we're going to talk about more in depth: third-party trust, full trust and payback trust, and we'll also talk about ABLE accounts. So first is the last will and testament, sometimes a common vehicle to establish a third-party trust as part of your will. As most of you probably know, a will specifies what happens to your assets upon your passing. I would say that any type of planning with regard to a will should not be a do-it-yourself endeavor. There are, online programs and things of that nature that people use to set up wills. But specifically, if you have an individual in your family with a disability, making a will should not be a do-it-yourself endeavor. You want to consult with an attorney who has experience in special needs matters. We actually provide an attorney list. I don't know if we have them down here, but we provide an attorney list that has lawyers who have special needs experience, who we feel comfortable working with. It's certainly not an exhaustive list, but we feel comfortable recommending these firms. It's broken up by geographic location, so if you have any questions about needing to find an attorney who has special needs experience, please let us know and we can get you that list. So if you die without making a will, your assets will pass according to the laws of intestacy. While that may still funnel the money to the people that you would intend to leave it to anyway, the spouse, the child, whatever the case may be, the key thing to understand is that the people receiving the money via the laws of intestacy will be receiving that money outright. And again, we're looking at an issue of having government benefits be in jeopardy. So we'll first talk about, we'll talk about sort of the components of a special needs trust, but we'll talk about why using a third-party trust is a better option than just leaving things up to the laws of intestacy. So special needs trusts are designed for beneficiaries with disabilities. We have beneficiaries who have intellectual disabilities, physical disabilities, mental health, addiction. So we here at Achieva serve a lot of different beneficiaries, but of course the individual needs to have some disability to benefit from a special needs trust. The assets in a special needs trust are used to supplement the life of an individual, so to provide supplemental and extra care for the person that's not covered by their government benefits. The assets also need to be for the sole benefit of the beneficiary. And when we talk about supplement, really there's a lot of things that we can spend special needs trust money on: clothing, vacation, medical needs, entertainment, recreation, transportation. Again, a lot of things, that a person needs in their life that's not going to be covered by those benefits. One thing we have to be mindful of is that expenditures that are being made out of a special needs trust should not supplant government benefits. So as Maria was mentioning, specifically for our SSI beneficiaries, the cash benefit that they receive monthly is meant to be spent for shelter costs, so rent, utilities, food. So if we're making expenditures out of a special needs trust for those items, the individual could receive a reduction in their SSI. So we're going to try to avoid, that reduction occurring and not spend trust funds for housing, food, and utilities, and we don't provide cash access to individuals either. We do home purchases, accessibility renovations, car purchases, those types of things you can do out of a special needs trust. So some of the key components: first, there are 3 types of special needs trusts: third party, often called a common law trust, payback, and pooled. We'll talk about each of those, the key characteristics of both, in the next couple of slides. One of the things that will need to be considered in creating a special needs trust is who will act as the trustee of that trust. So who will administer the funds, who will make the distributions from the trust, and sort of be the person that stands in between the beneficiary and the assets. With a third-party trust and a payback trust, you can have a corporate trustee and an individual trustee. You can have them both. You can have one or the other. But with our pooled trust, you do have to have a nonprofit corporate trustee be the trustee. I used to just like to mention, people often ask, how do you know who to make trustee? We find that it can work well to have an individual and a corporate trustee. The individual trustee sort of brings to the table personal knowledge about the beneficiary, the likes, the dislikes, the needs, the players in the person's life. But the corporate trustee is doing the administrative work, so keeping the books, making the distributions, cutting the checks, taking the daily calls, doing the tax returns. So it can be a nice option to have a co-trustee situation so that the individual sort of isn't burdened with the day-to-day matters, but again is still providing that personal knowledge that the corporate trustee may or may not have. And again, the assets in a special needs trust are going to be considered exempt and not affect an individual's eligibility for their government benefits. And as Maria mentioned, for straight Medicaid, SSI, an individual can only have $2,000 in assets. Waiver allows a bit more than that, but again, I think we can all recognize that's not a lot of money to have in someone's name, and it isn't going to go very far in terms of supplemental care, which is where the special needs trust can come into play. So the first type of trust we'll talk about is a third-party trust, and probably the most relevant in terms of special needs planning. Sort of the ideal when we're talking about making a future plan for a special needs individual. This is the type of trust that is going to be funded and established by an individual other than the beneficiary. So family, friends, someone that's not benefiting from the trust will establish a trust, will also fund it, and the money in the trust will keep the individual eligible for their government benefits. Sort of one of the biggest, when we talk about the differences between the 3 types of trusts, I think sort of the most significant is what happens to remainder funds, and we'll see when we talk about payback and pooled trusts, we'll see why. But with a third-party trust, Remainder funds, so these are funds after the beneficiary passes away. The trust document itself will say where those monies go. So whether it's to other family members, friends, charities of the choosing of the grantor, it creates flexibility. It allows the grantor to, preserve a legacy for people other than the individual with the disability. And again, with that, there's no payback to medical assistance. We'll talk about the payback trust and sort of how that works. The other nice thing with special needs trust is that there's no age limit. An individual can be 10, they can be 90, and they can still have a third-party special needs trust. We'll see with the payback and pooled that that's not an option. So, again, the biggest thing here is that these third-party trusts may be a part of a will. They may be a standalone document. They can be in existence during the life of the grantor or the person is establishing the trust, or they can just be funded at the death of the grantor. So the second type of trust is a payback trust, and we'll talk about payback trust and pooled trust sort of in the same terms. This is if, for example, an individual doesn't have a third-party special needs trust. So maybe, parents are leaving money directly to an individual with a disability. They've not done special needs planning with regard to a third-party trust. These also can come into play when people come into, say, settlements. The key fact with a payback trust is it's first-party funds, so not money belonging to someone other than the beneficiary, but actually money belonging to the beneficiary, his or herself. Some of the key components. First, an individual has to be under the age of 65 to have a payback trust established. As I just mentioned, with the third-party trust, there are no age limits, but we can't establish a payback trust for anyone over the age of 65. The beneficiary must be disabled. The trust can be established by the beneficiary, a parent, grandparent, a legal guardian, or the court. And again, key point, where do remainder funds go when the beneficiary passes away? First, with a payback trust, they must go back to the Department of Human Services to pay for any medical assistance the individual received during his or her lifetime. If there's money left over after that payback, the money will go to, according to the trust terms, so to, again, family, friends, charities of the person's choosing. But it's critical just to remember that, people that are on waiver who have complex medical situations can have bills with DHS. We see bills tens, hundreds of thousands into the millions of dollars. So, even a substantial trust, there may not be money left over after payback. So we want to, again, avoid leaving money directly to an individual because a payback trust, while it can capture those funds, the ideal scenario is leaving the money directly to a third-party trust so we don't have to worry about payback to the state. As I mentioned previously, with a payback trust, you can have an individual or a corporate trustee. That's also the case with a third-party trust. You can have an individual or a corporate or both, as I'd mentioned. And key component about a payback trust, you do have to have the trust drafted by an attorney. We'll see with a pooled trust, that's not the case. But with a payback trust, it has to be drafted by an attorney, and it has to have that payback provision. So a pooled trust, sometimes called an over trust or a D4C trust, similar to a payback trust in that we're typically going to be talking about first-party assets. You can put third-party monies into a pooled trust, but typically we're going to talk about first-party monies, money belonging to the individual with a disability. Like a payback trust, it can be established by the beneficiary, parent, grandparent, legal guardian, or the court. But key point, again, about remainder funds. So with pooled trust, and specifically with Achieva Family Trust, pooled trust, any funds remaining in the account after the beneficiary passes away stays with Achieva Family Trust and is spent through our Charitable Residual program, and we'll talk a little bit about that in a second. But again, there's not an option that it's going to be left to family or friends or charities of your choosing. The pooled trust is going to retain the funds and spend it for charitable purposes. We do pool all of the funds in the pooled trust for investment purposes, but each account is accounted for separately. The nice thing about the pooled trust is that you do not have to have a trust document. We have standard form joinder agreements that are filled out basically asking for biographic and demographic information on the beneficiary, and we just need that joinder agreement and funds to establish the account. So for small settlements or small inheritances that are left directly to an individual, maybe someone is left a life insurance policy, a pooled trust can be a nice option because you don't have the drafting costs up front, and you're probably not worried about residual funds because if the trust isn't that large, the likelihood is that the money will be spent on the beneficiary during her lifetime. So we'll talk a little bit about the charitable residual fund. Monies in this account are available to children and adults in Pennsylvania with disabilities. You don't already have to have a trust with Achieva. Again, you just have to have a disability and reside in Pennsylvania. We provide grants for individuals, camps, medical equipment, home adaptations, vehicle modifications, iPads. We do all kinds of different things for individuals with disabilities. I think we've spent, Jen, over $4 million in total in the existence of the Charitable Residual Fund. So if you have anyone that you know that has a need that isn't being met by a government benefit or by a family, you can apply online at achievafamilytrust.org. The applications are reviewed quarterly. And again, even if we can't cover the entire amount, we may do partial. It's just a really good program. And again, these funds are coming from money that's left in the pool after beneficiaries pass away. So Jen's here in the back. If you have any questions, you can certainly give her a call or email her. So a couple of things, just sort of our myth and fact section. You don't have to be rich to have a special needs trust. I think a lot of people sometimes come to these events and think this doesn't apply to me, I don't have a lot of money, I don't plan to leave a lot of money to my family member. But the fact is you can open a trust with us for a minimum of $500. So we have trusts ranging from that small, into the millions and everything in between. And again, a proper estate plan is critical. You want to consult with an attorney, talk about what makes the most sense for your family, and if at all possible, you do want to establish a third-party trust for your individual family member with a disability. That trust is going to provide the most flexibility, allow you to preserve legacy, and just avoid, again, some of the provisions like a payback provision with a payback trust or a pooled trust retaining fund. I want to talk briefly about the ABLE Act. The ABLE Act was signed into law by President Obama in 2014. It creates a new section under the 529 section and the IRS code. These are actually 529A accounts. And they allow individuals with disabilities to save money and spend money for qualified disability expenses. A regular 529 plan, if you're familiar, allows people to save for education expenses and make expenditures out of those accounts for anything education related. ABLE accounts similarly allow people to spend for qualified disability expenses. What that means, we've been to many seminars on it. While this is a relatively new program, it seems to be virtually anything. Again, a lot of the things you can spend a special needs trust money on, like recreation, entertainment, transportation. But one of the nice things about the ABLE account expenditures is that unlike a special needs trust, if you are spending money out of an ABLE account for rent, utilities, or food, so those shelter costs that SSI is meant to pay for, Social Security is saying that expenditures out of an ABLE account for those expenses will not create the 1/3 reduction as it will with a special needs trust. So, we have individuals who may have a special needs trust, but they're also funding an ABLE account and using that account to pay their rent, to pay for food, to pay for their utilities. So it can be sort of a nice way to complement one another with the trust and the ABLE account. A couple of things to keep in mind about an ABLE account. There is a contribution limit. You can only contribute up to $15,000 a year from all sources into your ABLE account. Special needs trust, there are no limits in terms of how much you can contribute into an account. Also with the ABLE account for SSI beneficiaries, once an account gets up to $100,000, the SSI benefit will be suspended until it's back under the $100,000. The Medicaid that's attached to the SSI won't be affected, but the cash benefit will be. So again, $100,000 limit for SSI beneficiaries. Again, we don't have those types of limits with special needs trusts. Another thing to just keep in mind with ABLE accounts, they are owned by the individual with the disability. So for some people, that's a great option. It allows flexibility. A person doesn't have to consult a trustee when they want to make an expenditure, when they want to buy something. But for other beneficiaries, that's not a great option. I know that, in particular, we have mental health beneficiaries who it may not be a great option for them to have sort of unfettered access to the funds. If there's a concern that the money is going to be spent, all in one shot or very quickly, that may not be the best option. You can have authorized signers on the ABLE accounts, but the fact still remains that it does belong to the beneficiary, and they do have the discretion to do with it what they want. Another limitation, just to mention, you do have to be disabled before the age of 26 to open an ABLE account. There's talk about changing that to the age of 46, but as it stands right now, you have to be disabled before 26. So just an age limitation to consider there. If you do, or you're interested in ABLE, you go to paable.gov. From what we understand, it's fairly easy to sign up for an account. It'll function sort of similar to a bank account. There are a couple different options in terms of how the assets will sit. It can be in an interest-bearing checking account, and there are some investment options as well. And just lastly, and again, this is when you're talking about your estate plan and planning for what happens when you're no longer around, some things you want to consider, during the lifetime of the individual with a disability. So parents are natural guardians for their children until the age of 18. Once the child turns 18, reaches that age of majority, they do have decision-making ability like anyone else. So, and I think that that's when we're talking to people, talking to parents specifically, that's sort of jarring. They're used to, for those first 18 years of their child's life, they're making decisions, they're talking to doctors, anything financial that needs done, they're having no problem accessing those records and being involved. At 18, for the individual with a disability, technically speaking, doctors, hospitals, financial institutions reserve the right to no longer talk to the parent. They lose sort of that ability to make decisions. So you want to consider a couple things, powers of attorney or guardianship. So powers of attorney, a healthcare power of attorney is a document that an individual, and not just with a disability, any individual signs that appoints an agent that can make healthcare decisions for the individual if they're unable to make them. Financial power of attorney, similar. You appoint an agent that makes financial decisions on your behalf in the event that you're unable to make them. And again, I want to just stress this isn't just for people with disabilities. Everybody in the room should have these documents so that if something were to happen to you, you are appointing someone that can, write checks for you, pay your bills, make medical decisions, those types of things. The key part, though, to consider for individuals with disabilities is, does the person have capacity to sign these documents? They are contracts. The individual will need to sign and make the appointment. For some people, that's not possible. If they don't have the capacity to sign those documents, they're not going to be able to execute powers of attorney. In that case, guardianship exists in Pennsylvania. This is a formal legal process in which essentially the rights of an individual are substituted by someone else's. So there was a hearing, there's evidence, there's testimony that's basically saying, this individual cannot make his or her own decisions. We need to put someone in place of that person to make those decisions. So again, for a lot of parents at 18, when their child turns 18, that's what they want to think about. Can we do powers of attorney, or are we going to have to go through the time and expense of guardianship? Obviously, powers of attorney are more preferred, they're cheaper, they're easier, and again, they're not as restrictive as guardianship, but there are going to be circumstances where they're not going to be an option, and guardianship will be required. And again, just recommending talk to an attorney about, whether there is capacity for an individual to sign one of these documents. Unfortunately, sometimes it is a subjective decision. My background is a little bit more in elder law, and we would have individuals come in, elderly people who on one day, might have seemingly perfect capacity. They were very aware of what was going on. They were perfectly lucid, but another day not have a clue what year it is, not have a clue what day it is. So, again, capacity is subjective, and there are going to be circumstances where it's going to be quite obvious that someone doesn't have capacity. But again, I recommend talking to an attorney about that, and you might even need to consult multiple attorneys to see if the individual has capacity. So just sort of wrapping up, some of the things that Maria had mentioned, our future planning activities. We do have a monthly newsletter. If you're interested in getting on that newsletter, please let Maria or Patty know. They can add your email address to the list. We are doing speaker series just like this, typically in the fall and winter months, first Friday or second Friday of every month? Second Friday of every month on a variety of topics, benefits, trust, anything that might be relevant for individuals with disabilities and their families. We do presentations, vendor fairs. We do provide a free legal clinic. We're hoping to do another one this fall. Basically, attorneys that are familiar in the field come here. They give their time, give free half-hour free consultations to individuals with disabilities and their families, obviously with the option for the families to follow up with them. And then we do have our free personal planning guide, which Maria talked about, and sort of a little more details on that. As Maria mentioned, it's a fairly long document. It's very comprehensive in terms of, a family member describing what their relative with a disability likes, doesn't like, needs, doesn't need, and, healthcare stuff, financial stuff. So, again, it's a very long document in the hundreds of pages. So feel free to reach out to us if you need a hard copy of that. It's also available online. Okay. I'm going to turn it over to Darren.
Thank you. My transition it down here, some more room for the worksheet. Thank you, Jackie. Thank you, Amy, Maria, Patty, and Michelle as well. We have Consultant appreciates the opportunity to collaborate together. This is something that when Kim Fleming, our CEO, reached out to me, I was very excited for. She did not realize at the time that my family's tie back to Achieva actually goes back to before I was born. So I have two older brothers. One is a high-functioning mosaic Down syndrome. So we've been using Achieva services for over 36 years now. So very excited to kind of coordinate and bring the financial planning element to their future plan that they've already taken so far today. The goal is really going to be to give you a quick 5 to 10 minutes on Heffer & Tillotson, really who we are, what we do, if you're not familiar with us already, and then we'll spend the majority of the time going over some financial planning elements. You'll see on the slide there listed for the agenda, which we have today. But if you flip past that, you'll see bullet points and then a picture of an individual. That is Willard J. Tillotson. So the name Heffer & Tillotson was the two last names of Art Hefferon and Willard J. Tillotson. Art Hefferon was Willard's father-in-law. I created the firm back in 1948, so this is 70 years we've been in Pittsburgh. We are the largest financial planning family-based private firm in Pittsburgh. So we have clients all across the country, but we have offices only in the Pittsburgh area. I'll jump real quickly to the following page. You'll see a picture of our offices. We have 6 locations in and around Pittsburgh. As north as Butler, as south as South Point. We have a Greensburg location, 2 offices downtown, as well as the Wexford location, which is our largest as well, too. But going back to the previous slide, we manage a little over $11 billion in assets under management, and our key focus really is focusing on financial planning and wealth management. Mr. Tillotson, a long time ago, realized that there was not really the right individuals to kind of spearhead and coordinate the levels of financial planning. We're talking about investments is something that most individuals will do right away as you walk in and talk to a financial advisor. But there wasn't really a process to coordinate everything. So to look at the estate planning side, to look at the insurance planning side, the education, the income planning, the tax planning, and tie it all together before you make the recommendations on investments. That is something that he kind of organized. The firm calls it our master plan process, but it really is it's kind of the name for just going through a deep dive of financial planning to get organized for that individual. So that is something that they view is important as far as their team approach. So if you look over on the following slide, you'll see a circle with a variety of boxes listed around that. The firm is smart enough to realize that no one person can be an absolute expert in all areas. So we have teams with underneath the umbrella of Heffer & Tillotson that specialize in certain areas. Now, my background, I spent the first half of my career in our financial planning department, so I was the nerd with the calculator, calling Social Security, doing pension analysis, doing all the financial planning projections. The second half of my career being as a financial advisor, like the other roughly 81 or 82 that we have here at Heffer & Tillotson. We have individuals that focus and dedicated their entire lives to just focusing on fixed income and bonds, and those that are focused on just the analysts and the behind the scenes. Where the advisor is kind of the key person that works directly with the client, and then we lean on the resources and expertise of everybody else at the firm to make sure that we can bring those resources to our clients. You'll see the first bullet that mentions there, a direct relationship with a financial advisor, individual or a group. About half of our advisors work independent as just a solo advisor, and the other half work as a 2, 3, or 4 advisor team. So it's just more of a preference of those advisors. You will often see the theme of a senior advisor who's a little bit older, someone more mid-career, someone more younger, for more generational planning. We have a lot of clients where their top concern is, well, if my advisor is the same age as me and I retire and he's retired, the whole process gets started over with someone new. So we have that more generational planning. You'll see individuals on a team about 10 or 15 years apart in age so that we can work with grandparents, parents, kids, and grandkids kind of in perpetuity to make sure that their wishes continue all the way down. So that is something that we've been doing for a while. You're seeing the industry do that as well, too, as far as larger teams of advisors working together. On the slide after that, listed really just kind of talks about it's hard to summarize it all in one page, but we are structured as a broker-dealer. So it really means we have the ability to work with a client in any capacity. We have the ability to work with commission-based investments, to work with a fee-based relationship, to work on a discretionary basis where you have the team actively manage the account, or work on a non-discretionary basis where it's kind of a partnership between the client and the advisor to pick the investments together. We also have, as of recent in 2018, we have more impact investing. We've seen people have a strong interest in being socially responsible with their investments, no firearms, no tobacco, things of that nature. So we're able to complement those investment preferences. So that is really kind of, given the size and the nature of how we're structured, we have the flexibility to accommodate those preferences differently with each client. But that gives you just kind of a general snapshot of the firm. And there's some key individuals you'll see pictures of on the following slide where it talks about our portfolio management team. We have over 80 advisors that work at our firm, but we do not have 80 advisors each going off and doing their own thing as far as designing portfolios and providing research and guidance. We have a centralized portfolio management team. They all have a few extra gray hairs than myself, and you'll see they have a lot of years of industry experience as well, too. Made up Kim Fleming, who's our CEO, and the daughter of Willard J. Tillotson. Jim Meredith, who has been one of the original 10 members of the firm, and he has also is the key host of our radio show on KDK from 9 to 11 on the weekends. Don Belt, Tim Davis, Kirk Carlson, and Brian Coble, and each of these individuals are also supported by analysts who are constantly following economic conditions and reviewing mutual fund and ETF managers. These are not the individuals that are day in, day out sitting in client meetings. They are behind the scenes doing the analysis and research to determine what our clients should own and why. So they are really kind of the core group that's, if you have tens of thousands of investments that exist in the industry, these are the individuals who ultimately screen out and determine what is in the best interest for our clients. The following slide, you'll see a snapshot. When I talk about doing financial planning, today's goal was to really kind of encapsulate the Financial Planning 101, building that core foundation for you and or the individual you're caring for with special needs, and to serve as a primer for kind of a deeper dive that you may want to do down the road. This really kind of is a one-page snapshot that talks about all the areas that you should be thinking about and or talking about with the financial advisor. So it really kind of encompasses what we call our master plan approach of doing financial planning. Investment planning, retirement income planning, tax planning, education savings accounts, insurance, extended care, or also more commonly known as long-term care or nursing care, estate planning, legacy planning, cash management, and mortgages and lending. Each one of those you could talk about at length and should as you sit down and discuss your personal situation a little bit more closely with an individual. It's hard to give kind of blanket advice in many of those areas, so we will give you considerations and things that we think that should really ultimately be on your radar. But I just wanted to keep the coverage to who we are, what we do, a little bit smaller so we can focus on time. If you have specific questions about the firm, by all means, we can answer those at the end as we go forward. As we transition forward, we'll go into start kind of look at talking about some of the smart financial planning considerations. I put this slide in here mainly, it seems pretty straightforward that most often everyone's best interest is to focus on your financial planning first before you start caring for somebody else's. In our role, we've seen most people lead with their heart and maybe not with foundational principles of financial planning. So you tend to focus your attention on what has the highest level of emotion in your life. By focusing on financial planning for yourself first and making sure that is secure gives you the ability to then care for more people at a higher level as you go forward. So really making sure that if you are caring for someone with special needs, that you focus on your planning and their planning kind of in tandem and not just focusing solely on theirs first. Because if you are stable financially, you will be able to care for that person for a longer period of time a little bit more efficiently. So with that theme, as we go throughout, these considerations will apply to yourself and your family as you care for an individual, but also specifically to that individual planning with special needs themselves. So we'll start kind of more Financial Planning 101, emergency reserve. So these are in budgeting. These are everyone's least favorite things to be focusing on. So there's a side handout that you guys will have. It says household expense worksheet across the top. There's a million different versions of budgets, and you've probably seen and gone through different versions of them. That is something that we would highly recommend you go through in some level of detail. Not by rounding off and putting roughly 100 or roughly 200, but by pulling out your credit card statements and your checkbook and making sure you have an accurate view. This is easily the most underestimated item that we talk about in our first financial planning meeting, where people will say, oh, I roughly spend about $1,500 to $2,000 a month, and my net income is this, but somehow this other income seems to be disappearing. So most people are not amortizing the one-time expenses per year, the cost to put new brakes on the car, the extra cost for a vacation or travel that occurred that year. So make sure you're taking all those expenses, dividing them by 12, and including them into a fund that would be actually in the budget. I often challenge clients to bring this to the first meeting, but then we'll do the reverse budget, where most people know what their net income is. So you can look at your net income for the year, and you could just subtract out what you are saving, and you're spending everything else. So that's the faster way to go about going for it through a budget. But I would recommend doing both, seeing where the gap is to make sure that you have a comfortable view on where dollars are going as kind of stage one. Emergency reserve, extremely important. Before you can really dedicate yourself and take other steps in financial planning, we do think it's important that you have that buffer so that if something goes wrong, you have the flexibility to protect yourself, not racking up debt on credit cards or not having to pull out expenses in a down market. Having 3 to 6 months of cash reserve that covers all of your core household expenses is a common recommendation and something that we strongly endorse. We would like to see people get to the point where they have half a year's worth of expenses set aside in cash or in a money market that would be available so that something pops up, you're not derailing your existing plan. It's not a lot of fun to see money sitting there that you can't spend, but it is something that it is there for a specific reason. If that 1% thing pops up in the middle of the year, it keeps you from derailing everything else. And so the budget worksheet is there on that side handout page. We would recommend that as your kind of homework assignment as you leave today. The next page talks about really knowing what you have, going through and do a comprehensive family inventory. So documenting all your existing accounts, your investment accounts, your debt obligations, real estate vehicles, business interests, different types of insurance coverages. There's a wide range of items that should be reviewed and revisited on a pretty regular basis, and then clearly going through and documenting all and any types of income sources. Looking at investment accounts, they're a deeper category because they can be different based on their tax nature. If you have a 401k or an IRA, for most people it's all before tax dollars you've not paid any tax on yet. If you have a brokerage account, it's most often funded with after-tax dollars. So they're treated a little bit differently whenever you start taking income out later, and they should be planned for a little bit differently. So having a good comprehensive view of what you have before leading into that meeting of sitting down with a financial advisor is a phenomenal starting point, because it's going to be something that they're going to be bringing up in some of their earlier questions is how are we structured today, what are we really going towards, and what can we use based on what you have today. So making sure you have a good view of how that is set up. The next item listed there talks about impact of account ownership and titling, and this applies to how you and or your spouse or siblings may own assets, and also how you may own assets between you and a special needs individual. There's also on the second page of the packet with a green bar across the top, it talks about different types of property ownership. And this, I wanted to provide as a resource. We will not go through this in a high level of detail, but really just to be aware of the different types of titling and ownership and how that can impact the other individual. For example, joint tenancy with rights of survivorship is one of the most common ways for individuals to own assets jointly here in Pennsylvania. You'll see that's listed in the middle of the page there. You can have an unlimited number of owners who can own jointly on an existing account. The owners can be essentially anyone. It could be you, or it can be an organization, an LLC, a trust could technically own a portion of a piece of that. But one of the things that ownership during life is viewed as equal regardless of who contributes the assets. So one of the things we often see is an elderly individual, their children will be put half onto their checking or savings accounts or put half onto their brokerage account as a means to make things easier for access and check writing and being able to control, as opposed to going the route of getting a financial power of attorney and just being able to sign on their behalf. Being aware that by adding someone's name, you're actually instituting a gift. You are changing course of action. You are having an impact on what may happen to the cost basis of those assets or where those assets may go when one spouse passes away. So most people may or may not realize when that omits that account from passing through your will if you add a second individual and it's held joint with rights of survivorship. So before you make any changes to titling for ease of use and ease of your daily activity, there can be other ways for getting check writing capabilities at a bank for a bank account, or having a financial power of attorney, as Jackie mentioned, is something irregardless of level of planning for special needs, non-special needs. having a will, a financial power of attorney, a healthcare power of attorney are relatively recommended pretty much across the board in most financial situations. But we would want you to be aware of the different opportunities that exist out there. And there are some that can only be owned between spouses as well, too, such as tenancy by entirety or being an item classified as community property. So this is more of a quick reference guide if you have items such as a second property or you're considering what to do as you get ready to possibly fund a trust or consider funding a trust for a special needs individual. You are going to want to revisit titling of all assets kind of across the board. So just wanted you to have that piece. We'll transition on to the following page into something Jackie started to already touch base on, beneficiary designations. This is easily the area we see the most mistakes whenever we start initially doing financial planning with individuals. I have, and from talking to other colleagues, the number of times we've seen an ex-spouse still on a 401k plan, or we've seen individuals who have, their children have been divorced, where we have the divorced spouses of those individuals still on there. The beneficiary designations and knowing how your accounts move after you're no longer on this earth is extremely important. Most people think that if I have a will, I can check that box and things are accomplished, but they forget that the primary path for most people's savings, being a 401k plan while you're at work or an IRA, do not actually pass through your will. They pass by their own beneficiary designations. So there was a form whenever you set up that employer plan or your traditional IRA that controls where that account goes. And unless you've worked with an attorney to draft custom language to send that into your will or into a trust, it is likely going directly to an individual that you listed on that form when you initially set it up. Anyone who's been working at a job, back the same job whenever they had children, there's a good instance that if you have not revisited, you may or may not have added on all of your children as contingent beneficiaries as well, too. So it's something worth going out to any one of your accounts that could possibly have a beneficiary designation and reviewing those. We've included kind of a reference sheet, a worksheet to be able to fill out to do that. But I think it's something that most people overlook, and they make the assumption that if I have a will, this will control how everything will actually be transitioned. One of the bullets listed there is contingent beneficiaries. Most people also stop by having just a primary beneficiary. We would also highly recommend having the conversation with your significant other, with your family, as you are planning for a special needs individual to make sure that the primary and the contingent beneficiaries are all set up accordingly. There are a lot of instances where we see spouses simply list each other and think that, well, if something happens to both of us at the same time, this will just go through my will. Now, if this is a tax-deferred account like a 401k or an IRA, that could mean the liquidating or the total taxation of that entire account. So you could be giving, what's under today's tax rates, 37% of your account to the government voluntarily when you don't necessarily have to. So making sure that you're planning for all those what-if scenarios that are a couple stages out. Ideally, they never happen, but if they do, you want to make sure that you can control how your assets move as you go through those different stages. The one bullet mentions the custom beneficiary designation. This is something that most people will have a standard beneficiary form where they feel that they have to list an individual and then a second individual or however that would be set up. But you have the ability with many institutions to build in kind of the what-if scenarios where you can accomplish if so-and-so were to predecease so-and-so, I wish this, or if the account grows over this certain balance, I wish for this to be divided up in this fashion without having to force it to go through a will or a trust document at that time. So it really depends on the individual's, clients, and the family's wishes at that time, but it's to be aware that you have that option. Adding per stirpes or per capita to Latin terms, I don't know going back to their origin of why they're set up that way, but the per stirpes designation is one most people we come across that are not aware of, but they are striving for what the net result of having a per stirpes designation would be. If I run through the hypothetical that if you have a married couple that has 3 children, and their goal is to leave everything to each other and then everything to the children equally if something were to happen to both of them. If, God forbid, one of the contingent beneficiaries or one of the children predeceased at that time, and then the parents passed away, most beneficiary forms by their standard language would omit the heirs of the beneficiary that deceased. So you would be then splitting your assets equally between the 2 living children and not passing assets on to the contingents of the child that you had. So we see a lot of parents who their wishes are, well, if something happens to my children, my goal is that their 1/3 goes to their children, ultimately. The per stirpes designation, by adding that, so if you have the child's name with a per stirpes, the word per stirpes after it, depending on how the form is structured and set up, that it would often keep their third or their portion within their heirs. Most people do not realize that the default on many brokerage firms and many institutional forms will just simply, if one contingent is not there, it's an equal distribution amongst the remaining. Now, this is accomplished in a will in a much more fancy verbiage. It's usually a paragraph. It's pretty standard in most wills, but it's not a default in most 401k plans and most IRAs and most qualified plan legal or beneficiary documents. So if that is your wish, it's worth revisiting. Heffron Tillotson custodian is Pershing LLC, which is a national custodian. They're the third largest in the country. Their form is a little checkbox. It literally just says per stirpes, and you have to flip to the instruction page to see in size 6 font a couple pages later explicitly what that means. So it's often not discussed in the level of detail that it deserves, and it's something worth revisiting on all of your accounts. Now, most people just think of investment accounts, but if you're still working, you need to think of your group life insurance. So if your employer provides life insurance through work, if you own an individual life insurance policy, you need to be revisiting that as well. So all those different areas need to be looked at to make sure the primary and the contingents match up. The transfer on death and the payable on death, which is the last bullet listed there. So with brokerage accounts, so if you have an investment account at an institution, you have the ability to add a TOD, or a transfer on death designation. There are certain instances where this can make sense to do so to avoid the assets going through the will if that is your direct wish. But the transfer on death is taking a brokerage account which normally does not have its own beneficiary and adding one on. But the same facet, banks will allow, majority of banks will allow a POD, a payable on death, so that if you have a checking or savings account that you explicitly want not to pass through your will, be divided, or going into a trust, you can add the POD designation that will be transferred directly to that individual. It's usually a much quicker process. For example, our institution would only need proof of identity and a death certificate to then be able to do the administrative process versus it going through probate and dealing with a lawyer and going into a probate estate and then being divided up. If you're working with an estate planning attorney who charges a % of assets based on the probate estate, it also removes that account so that it's not part of the attorney's fee as well, too. It all depends on the structure of what you're looking to accomplish. That is before you would ever add that is a conversation you want to have with an estate planning attorney to make sure you have the appropriate amount of liquidity and everything you need, at your passing as well, too. So don't make that change without talking explicitly to an estate planning attorney. On the next slide listed there, it talks about just special needs trusts and funding options, and Jackie did a great job at kind of diving into the 3 core areas of the different trust options. This is just to kind of put a couple different items on your radar to get you thinking about different ways to potentially fund, but also to challenge you in thinking about at what stage of my life, at what trigger should we be looking to fund an actual trust. There's a lot of merit for funding trust in present day based on how assets are set up, funding trust over time with ongoing monthly contributions, but also setting up a longer-term plan to fund the trust at your passing or at the passing of your spouse. And what assets you use and how you structure that can be set up very differently. Again, I'll reference back to what I mentioned earlier. Before you look to fund the trust, it's making sure you have your core financial plan taken care of, and you look out 30 years for yourself to make sure that income is planned appropriately, that you can continue with the plan you set in place for funding and trust options. The first couple bullets that are listed there are probably the more common ones that you've probably already thought of at this point. Cash gifts and inheritance, litigation proceeds and investment accounts, and also listed there in the example of brokerage, IRA, and 401k plans. And again, that would be structured differently, whether it's a before-tax account like a brokerage account, or a tax-deferred account such as an IRA or a 401k plan. So those areas would be looked into based on how things would be structured. Now, life insurance proceeds can give you a lot of flexibility, but it comes back to the caretaker or the individual who is providing care for that individual's health, because the health controls the cost of what that life insurance would be and then determines if it would be a viable option to do so. A situation that if you have a family that's providing support and you have a low level of concern for care as all those family members are living because you have numerous individuals providing care and you have a care plan lined up, then having a life insurance policy provide an infusion of income if, God forbid, one of those caretakers were to predecease earlier than expected can make a lot of sense. This is something that my family personally has in place as that they took out over, I guess it's coming up on 12 or 13 years now, a life insurance policy on my mother as the primary caretaker for my older brother. If before myself and my other brother would be financially stable, we wanted to make sure that we knew we had an infusion of cash that would come in to provide care for my other brother. Now, this can be directed to a trust. It can be directed outside a trust based on the special needs personal situation. So it's something that would be important to consider the logistics of. You can go a lower cost approach if you're looking to cover a period of time, such as a term policy, which is a very common policy that young professionals or individuals will get to cover just normal life insurance while they're working, while they have a mortgage, while they have a car payment, et cetera. If you're looking to cover a certain period, knowing that that has an end date and it's your lowest cost to cover that many years. And then there's a variety of different permanent life insurance policies that would cover from now up until your age 100 plus to make sure that it's guaranteed to pay out. Different costs associated with all of them, different costs based on your health and really what you're using for the policy. A trust can own the policy or you can own the policy outright. Again, that's a conversation directly with an estate planning attorney and with the financial advisor to determine what's going to make the most sense. And what's nice is you can buy them in really kind of any incremental size. The cost is all relative to your health rating as you apply with the insurance company. Looking at how, again, personal property is titled is important. Going back to the sheet, we talked about different types of property ownership on what happens to that property and how does that impact or not impact potential existing trust and where does that flow. Is passing that to an individual that is getting government benefits, is that going to disrupt the plan? Is that something that should be held privately, or should there be specific bequests in the will to control how that is separated? Business interests in rental properties, royalties, and also gas, oil, and mineral rights get a little more complicated, but they are forms of income streams that can be used to fund a trust over a longer period of time. So it depends on how those are initially held as far as an ownership standpoint before you start looking. But these are all things that, if any of they apply to your life, you should be viewing those as considerations and talking points as you were to sit down with a financial advisor. And before we segue into kind of protecting the plan, on the handout as well too, I'll just reference the page. If you flip over to the third page there, it says knowing your beneficiary designations. We'll add this in addition to your budget. This will also be your homework as you guys leave today. And this is something I recommend to all of my clients, that they file with their tax return. They pull it out every year and just double check it. That you go through all of your 401ks, IRAs, your existing life insurance, your benefits through work. If you have checking or savings accounts that you're looking to add a payable on death designation, that is something that you'd be able to add onto there as well. Making sure you have a primary and a contingent and that they match up with your wishes pretty much across the board. So this is kind of a very simplistic sheet to be able to fill out and organize all of that set information. As we go on to the next two slides, we'll talk about protecting the plan. So once you sit down with a financial planning attorney and do your research to determine your course of action, whether it's a trust or a non-trust, or a trust and a complementing with an ABLE account or a variety of different elements, once you have that in place, I think ever more so important would be the actual ability to protect that. Again, financial planning goes back to having flexibility and controlling the items that you have control over in your life, and then planning for flexibility for the items that you do not. So if life throws you a curveball, you have the ability to still have options available to you. So within that, protecting your plan, clearly a high level of communication between all of those involved is extremely important. Achieva Family Trust, you'll hear these individuals often incorporate and recommend that over and over and over. If the heirs to your plan do not know the details of your plan, it's hard to execute and really kind of continue that and carry the baton. Completing a letter of intent, which I will highly, highly recommend. Achieva's personal planning guide that they referenced earlier, they put the information on their slide. It's available on the website. Heffron Tillotson in general goes into very comprehensive and meticulous wealth management. We were extremely impressed with the level of detail that they took their personal planning guide. The specific questions that kind of encompass that entire individual's life is well worth doing. So if you've not already downloaded that, I will give a second push to make sure that you do. Extremely detailed. Having that and keeping that with your legal documents would be highly recommended. Umbrella personal liability insurance. This is something that applies to someone protecting a special needs plan, but just someone protecting themselves in general as well. So from the time, our recommendation is from the time you own your first vehicle or your first home, you really should have some level of liability protection in place. And we would often recommend above what is the state minimums on your home auto policy and also your vehicle policy. Most people would have the homeowners and the auto insurance. On there, they have usually a level of $200,000, $300,000, or $400,000 of personal liability that would be on the homeowner's policy and that would be on the auto policy. So if there is a lawsuit against you relating to an incident, that will cover personal liability. Most people don't realize that if you say you're in a 3-car pileup and there's an accident that ultimately ends up being your fault, the auto insurance industry will often look at that as one incident. So you have a one-incident limit. If there are major injuries that occur in that situation, you can imagine lawsuits will easily be above the limit that's on that policy. So umbrella liability insurance exists starting for that core reason. Umbrella liability insurance is often sold in million-dollar increments, which may sound like a very high level that most people do not all need, but lawsuits often start with 7 figures and then work down. So that is something, if someone is already ready to gear up, and if there's a major injury or, God forbid, a death, that you will often see those lawsuits start at that level. So this is something that provides protection against the entire plan. Another reason we're very strong advocates, it's extremely affordable. So $1 million of coverage often falls in and around $200 a year for an annual premium, far less than likely than any other insurance you currently have in your life. And then adding additional levels of $1 million of coverage, $150 to $250 a year, we often see. It is nothing that Heffron Tillotson provides, but nearly every auto and homeowner agency that's out there offers that. So you can reach out. You're often not seeing commercials or billboards on the highway and no one's kicking your door down to sell them because of the structure and how it's associated. The insurance companies are not making their money based on selling umbrella liability insurance policies. So you're not seeing them well marketed, but it's something we highly recommend, that it provides that extra sleep well at night protection against what you're setting up with your existing family. Now, life insurance and disability insurance, this directly applies to the family members of those caring for an individual with special needs. If your ability to earn income were to end, think of what that would do to your potential to be able to care for that individual. Jim Meredith, who hosts our radio show and one of our founding original members, he's referenced the joke on the radio show in the past before, that if you had a machine at home that legally printed in U.S. dollars your paycheck every 2 weeks, would you buy insurance on that machine to make sure it doesn't break? It's like, at the end of the day, you are that machine. So if you do not have existing long-term disability or short-term disability through your current employer, it is something worth looking into. If your income stops, many years premature of your expected retirement, it derails really everything that would occur thereafter. So it's well worth looking into, as is with life insurance. A nice avenue and a consideration with life insurance, if you're going through a job change, most people do not realize that you can often, when you're going through an enrollment period, you do not have to go through a health screening to get up to their certain max level of coverage through the new employer. Now, if you were to go out to the market and you were to buy your own individually owned policy, you have to do a thorough health screening. But the government allows, if you're going through a life transition, such as a job change, and you're going through a company's enrollment period, you often have that 60-day or 30-day enrollment period to enroll up to the max of that employer's life insurance policy without going through underwriting. So it's because most group long-term or group life insurance policies are age-based. They're age and sex-based only. So you'll notice them as you hit different age increments, they go up in cost relative to the same of everybody else in the company. So it's something that's an avenue worth pursuing through your current group life insurance policy, but also looking at, if you do not currently have disability insurance, to make sure you have that in place too to protect the plan. Regularly reviewed successor trustees and the guardians that you have. That is something going in line with, once people will set up a plan, they will check the box, they'll take a deep breath, and they'll kind of set it aside and not really double check things, but making sure the successor trustees and the guardians you have in place maintain, and those are your wishes, and you look at those every 3 to 5 years to make sure that nothing drastic has changed in your plan, or there hasn't been any major tax law changes that would change your personal preference. If you go the path of having a partial corporate trustee and a partial individual, making sure that corporate trustee still reflects, and has all the updated information that you would wish them to have. Same concept with guardians. If you have a sibling you prefer to be your guardian, they happen to move out of the state, making sure you have the appropriate other guardians set up in kind of successor form. We will often recommend primary, contingent, and tertiary, a third level, because the more common thing we see is people do not revisit their legal documents, and they do not revisit their other areas as much as they should. So we're going with the assumption that let's plan this so that if you don't look at it, we can cover a lot of what-if scenarios that could occur down the road. and making sure that that is in place. The next item we'll kind of transition into on the following slide as we continue to on the protecting the plan. Staying up to date on changes in the special needs industry is another, really kind of falls as an obligation to anyone caring. And I'm speaking to the choir because you are all here getting updated information, which is great. But continue to tell those who are not or that you think would benefit from. The Achieva e-newsletter is phenomenal. I would highly recommend anyone not signed up on that gear into getting that information and staying on top of it. Imagine if the ABLE account ends up being a value add for your personal family and you did not stay on top of the industry over the last couple of years and did not realize it was an option and did not discover that until 10 years down the road. So tax laws change. They're permanent until changed is pretty much how the industry will look at it. So there's constantly new things coming to, I don't say coming to the market, but being available in the industry gets options or possible enhancements that you could be making that it really falls on the benefit of that special needs individual, but the obligation falls back to the family to be able to stay on top of those areas. And also in protecting the plan, right now cybersecurity and protecting one's credit we've seen that really spiral over the last 5 or 6 years. The Equifax breach is pretty common. Most people saw that in the news. About 40% of the country's personal information was downloaded onto the dark web. So there's other instances, if you look back, that didn't get the highest level of media coverage. Yahoo Mail, who had a breach back in 2013, thought 10% of the accounts were compromised. They snuck that in 2017. They realized 100% of the accounts were compromised. So if you ever had a Yahoo email account, your information was downloaded onto the dark web back in 2013. So imagine what people could learn from you by looking at your email for a couple months. A lot. They know where you bank. They know where your institutions are. They can see transactions. They can see change and confirmation of password changes. So the best defense really is being proactive about monitoring your credit to make sure you know who and how and when it is actually being used. The government-sponsored website is annualcreditreport.com. At minimum, we recommend you check that once a year, that you and your spouse and all family members, because you have to log in on a per Social Security number basis. This website will show you for no cost all credit associated with your Social Security number from the beginning of time. So it is the best way in the shortest period of time to catch if someone opened a cell phone in your name in Arizona, which is an example that we've seen. If there was someone tried to take out a loan or refinance, or someone tried to falsify your tax return and file it before you to get the refund. We've seen these grown exponentially in the industry. So being proactive and reviewing that, we are not concerned with what your FICO score is or how high your number is. It's just making sure that you're aware of everything that's associated with your credit or everything that's been pinged against your credit up to this point. The sister site of annualcreditreport.com is opt-out pre-screen. So this has actually existed a little bit before annualcreditreport.com. So if you get the annoying credit card offers and insurance offers in the mail and you're looking to cut that down, it also is a means to protect yourself financially. You can go on to opt-out pre-screen, you can print out a form, you can sign it, and you can send it off, and it goes out to all 4 of the major credit agencies to remove you from their mailing list. Now, this takes, from what I've seen from experience, I'm talking to clients, about 2 years to really see the net effect, because anyone who has bought your information off a block of names, they're going to continue to mail on it while they have it. But when they go to buy an updated block of names, yours will not be on that list anymore. My wife and I did this, and about a year plus, it started to trail off and work, but then we moved, and then you're back on the list. So if you have a name change or you move, you have to start the process over again. So worth looking into, worth filing, and just kind of trimming down whatever personal information will be circulating amongst the mail is a definite good option to be looking into. The next slide as we go forward just really talks about after you have, this kind of takes a stage past really protecting the plan and would talk and highlight more of some of the conversations you would have as it relates to your personal finances and the personal finance of the individual with special needs. Portfolio design and income planning, I think something that you'll hear talked about very heavily in financial planning is kind of planning for income for different stages of life. On that slide, you'll see listed there on the left side of the page the 3 circles, which this is a little clip art that just shows a very common structure in our industry called a bucket approach. So if you think about your money, and we'll just keep it simple, but in 3 different buckets, and we'll apply it to a retiree. And if the individual is fortunate enough to retire at 60, they need income from 60 to 70, 70 to 80, and then 80 plus. You can invest the assets you use for income differently for each one of those different stages. And this is a philosophy that can be applied to planning for trust and planning for the income for the special needs individual. If an individual the definitive income they need over the next 10 to 15 years, you may want to invest that differently than the income that you're planning for them for 20, 30, 40 years out. With different levels of risk and different levels of tax planning associated with that, and possibly different vehicles. So whether incorporating the trust, the able account, assets that are owned by the parents, or assets that may be in the actual name of the special needs individual, you want to earmark and plan for different stages of life as far as how they would use them. So this just shows a simplistic view showing that you would have your more conservative assets being used in the shorter term and your more aggressive, growth-focused assets to make sure you are able to grow those assets appropriately for the longer period. The triangle listed on the right side of there talks about legacy, wants, and needs. Financial planning always starts at the bottom and works its way up. So making sure that you cover all of the core needs to live your quality of life, and then planning for all the core needs for the special needs individual to cover their core quality of life is going to be what you're focusing on and what you build and put your most efforts into for a plan. The wants is the more fun part to kind of expand and build out the plan, the extra resources that are available to be able to incorporate, and then also the legacy as far as what happens to your assets after you're not here, after that special needs individual is not here. But this is more to kind of get you thinking about compartmentalizing the different accounts that you may have or your approach to being able to set up assets for that individual. On the following page, we go over talking about the importance of tax planning, and that starts to kind of transition into how the trust is managed, how assets outside of the trust is managed. And this is not meant to overwhelm, but more just to kind of give you a resource and to make you aware that the benefits of working with someone like Achieva Family Trust or having a financial advisor kind of talk through the structure of the different accounts. There can be a lot of value from a very short conversation about kind of breaking down how you're set up today. Short-term and long-term capital gains taxes, if you're talking about a asset that's not a 401k or not an IRA, that's a brokerage account or a checking and savings account that you would typically have, the interest and dividends and capital gains that you incur every year appear on your tax return. You get a 1099 that you give to your accountant at the end of the year that you pay capital gains tax or tax on the interest there. Now, whether you own an asset for more than 12 months or less than 12 months determines how it's taxed. So being aware of that, and whenever you're transitioning assets into funding a trust, being cautious about selling assets that would be viewed as short-term assets because you could pay higher taxes on that. So just kind of the awareness of when those assets were originally purchased and set up. Offsetting unrealized gains and unrealized losses when possible. That is something that, from conversations that Achieva Family Trust is already doing within the other pooled trust accounts, Heffron Tilton is doing as well too, or if you have an asset that is a gain of $5,000 and a loss of $5,000, you have the ability to kind of sell and transition both, keep a similar risk objective within the portfolio, but wipe away the potential taxable gain that's in the account. Again, this does not apply to 401ks or IRAs because they are tax-deferred accounts. But in a brokerage account, making sure you're aware of what the tax implications would be. 2017 was a very, very good year in the market with a lot of gains. So anyone that had losses in any of their accounts, there was a lot of merits in going through the individual tax laws to offset as many of those gains so they're not getting a big tax hit when they do sell them down the road. So anytime you can pay less dollars to the government, you're going to want to go down that path and take those extra steps. Year-end capital gains avoidance within a lot of the, again, non-401k, non-IRA assets, mutual fund companies that have large unrealized gains that are bundled into the mutual funds or the investments that you may own may issue a year-end capital gain distribution in the fourth quarter of the year. So it's being aware of the timing of when you buy investments to make sure that you can not unnecessarily pay those expenses. Proper tax withholding across income sources. This is less out of the trust planning, but more under your personal planning. Individuals, as they transition to retirement, you have the ability, for the most part, to control your tax withholding on all different income sources and all different asset distributions. So based on where we are in a market cycle or based on how you're planning or the risk that you're comfortable with, one may want to do higher withholding on Social Security and their pension and lower tax withholding on their IRA distribution so that they have to take less out of their investments. At the end of the day, you still have the same net spendable dollars. You can just control where you pay the government more from or where you pay the government less from. So if you're required, once you hit 70.5, to take what's called an RMD or required minimum distribution from IRAs, the government's way to make sure you don't defer tax dollars in perpetuity. If your goal is to keep that to an absolute minimum, you're going to want to have lower tax withholding on that so you can have the highest net amount distribution, and you can do extra on your Social Security or your pension income. At the end of the year, you have the same dollars withheld. You can be a little bit more strategic in how you would plan that out. You'll see also in the packet information as far as the handouts, there's 2 sheets. They say 2018 Heffer and Sullivan Quick Reference Guides. This is actually laminated on my desk. Our financial planning department put this together, and they update it every January. So there was a lot of tax law changes in December we get questions on. So this is our quick reference guide. It's as much data as we could cram on the front and back of 2 pages that you could still read that is on there. So it goes into, down the left side of the front page, all the income tax tables, talking about how the standard deductions have changed, what capital gains rates are, federal and estate tax planning information on Pennsylvania taxes. The second page talks about all of your retirement plan limits that you have, and there's 2 sections on Social Security planning and also education planning. So this is all the rules as they apply to 2018 that were effective after the tax law changes that occurred at the end of December. So we just wanted you to have that available as a resource. It's a little overwhelming to look at, but if there's certain areas you may find yourself being drawn to, that'll be a little bit more clear as you go through. And one more topic I wanted to make sure we touched base on before we open it up for questions on the following page would be just Social Security. So Maria went into talking a lot about how the SSI and SSDI and different Social Security, still not timing, but Social Security options. With your existing Social Security, with our focus on planning for income, one of the big takeaways I always try to make sure all clients have, as you're planning for your own personal Social Security, to think about the magnitude of the decision before you make it. Too often we see individuals come into our office and associate turning on their Social Security as a direct correlation on whenever their retirement day is going to be. I'm planning to retire at 62, I'm going to turn on Social Security, and that's going to be it. At the end of the day, that may be in your best interest to do that, but I would say make sure you do the due diligence, exploring all the set options before you do so. This is a simple chart that just shows the quantity of income that could be the difference between taking it at 62, your full retirement age, or age 70. So if you look down the left side of the page, it says claim at 70, it's $4,600 per month. In the middle of the page, it says claim at FRA, which is full retirement age for most people that is 66 or 67, or some period between. And also it mentions claim at 62, and then around 2,100 there. And you can clearly, if you claim it at 62, you have income for a longer period of time, but you incur a reduction to take that benefit earlier. The government says, well, if you want to tap into your Social Security earlier, we're going to give you a little bit less. And if you claim it at full retirement age, you get it later, but you get a little bit more. You claim at 70, you get it later, but you get, again, a little bit more. On the far right side of the page, down from top to bottom, it is the cumulative benefits that you would receive if you were to receive that amount per month going forward to age 90. And you can see at 1.54 million, 1.34 million, and 1.1 million, it's a very large source of collective income. So compare that number to the accounts that you have today to talk about the magnitude of how important that decision is. And the fact that it's a difference of over $400,000 of income that you would receive if you were to take it at 62 versus 70 is well worth looking at the timing of when you should take it. When we see 2 spouses together, there can be a lot of merit in one spouse taking it early to give you an income source and one spouse delaying. Most people may not be aware that if one spouse passes away and you're still married at that time, the surviving spouse gets the higher of the 2 benefits. So by one spouse delaying and locking in the absolute highest amount, you're providing the highest possible survivor benefit to protect your family thereafter. Whereas if both spouses take it right away at 62, you may have locked in a little bit of a lower benefit amount. Not to say that in all scenarios delaying is the best path, but you should do the math and make sure you apply the principles of Social Security as they may fit your situation. Now this could mean if you do retire at 64, maybe you work some fun part-time job between 64 and 66 to allow yourself the ability to delay that 2 extra years. Not fun advice from an advisor to a client, but it can make a lot of financial sense over the long term. If you have the ability to delay, it's worth looking into. But if you don't, taking it early is not necessarily viewed as a bad thing either. It's just making sure that you've looked at all options, crossed them all out until you get down to the one that's most efficient for yourself. Those are the main topics I wanted to make sure we covered. It's about 20 till, so we can open it up to questions, I guess, for all of us.
I got a question there. When you were on the beneficiary page, you talked about services. Okay. The scenario you used, two parents pass, three siblings, one passes, money divided equally between the two that are remaining. What if there are a third generation below that? If the language isn't in there, that siblings who pass, that money doesn't necessarily go to their family and their kids unless the language is put in, I'm assuming?
So to recap for those that are listening in online, the question was reflected on the slide about the per surface designation. If there is a tertiary level of beneficiaries on the account, would additional language need to be included to assure that it gets evenly distributed amongst them? I would say 90+% of industry forms, if you're dealing with an investment firm or a brokerage firm, are not set up to include tertiary beneficiaries on the account. So at that stage, you're often looking at a customized beneficiary form. So once you go down the path of a custom beneficiary form, you have the ability and flexibility to modify to fit those what-if scenarios appropriately. That would actually be the encouraged path. If you're looking to incorporate a tertiary level, that you would want a custom beneficiary form with the what-if scenarios ultimately built in. Does that answer your question? Okay. But it's rare, and I've seen hundreds of beneficiary forms. As a default on the form, they're only required to offer a primary legally. Nearly all will offer fields for contingents. I've almost never seen the tertiary field as a default of the form. The forms will have a supplementary form that allows for a custom addition. Any other questions from anyone online or anyone in the room?
I have a question about the ABLE account and about distribution from the ABLE account. How you know, I'm from Bulgaria and my daughter is going to grow in the United States. We're now American citizens. But what if we want to use the services in other countries? Even if for the American citizens who find a better medical provision somewhere else out of the United States, can they use ABLE account as what was the word?
Pay for services?
To pay for the services, yeah. Eligible services. Is that through the ABLE account for out of the United States? I know 529 is probably if you use education out of the United States doesn't work like that. Is it ABLE account or similar?
I mean, I would imagine that it would be. I mean, if you're spending it for qualified disability expenses, which would be medical expenses not paid by any kind of government benefit, I think that you could, although I've never actually been asked about using ABLE accounts internationally.
I can't imagine that.
That's the first time, good question, the first time that has come up. Look to see if there's anything in the law that would prohibit the funds from being used out of the country.
Yeah, maybe here in the United States it's not very common for people to travel for medical reasons, but in Europe it's very common to go from one country to the other country. Like here you just go from one state to the other state, but these services are eligible if you find a better medical service somewhere out of the country.
Yeah, and generally how the distributions work from the ABLE account is you request a distribution and it comes into your bank account, and then it's incumbent upon you to maintain, the records of how the money was spent in case there's any questions. So I would think that you could use it for medical expenses, but we can check into that. That's a good question. We'll check into it.
We have your card. Yeah, we do.
Get back to you.
Yeah, that's an interesting question. Yeah. So generally, Darren, I just wanted to say, I think we are recognizing that the financial aspects of that future plan really are essential to integrate with the legal and the service aspects. And again, I'm assuming that at your firm you are working typically with attorneys and families who are coming with their estate plan and really coordinating that plan.
No, that's a correct assumption. I would say more often than not, the individual that's approaching the firm is within a few years of retirement. Their legal documents are 25-plus years old, so it's really kind of revisiting and re-ramping. We do have a lot of individuals that come to us immediately following designing an estate plan so that we can then coordinate and update, which is great. But no, the collaboration is kind of one of the foundational points of planning that we want to be a trusted advisor that is kind of spearheading with you the coordination with estate planning, with income and tax planning. So dealing with outside attorneys and outside CPAs is a kind of a regular practice.
So it's a good segue, too, because I think as a result of these sessions, these 5 planning sessions, Heffron has offered, we will be offering individual consultations for families. And we actually have a sign-up sheet that I didn't mention earlier, but if anyone is interested in an individual, these would be no-cost consultations with Heffron. Because what we're trying to do with all of this is encourage, again, planning as early as possible and to get ahead of retirement, for example, and really start to look at your financial situation, but also look at it, again, in the context if you have a family member with a disability, how does that all fit in? How does it all affect that plan for your loved one with a disability, as well as for yourself, as Darren is saying. So, so again, we're hoping to, and this was also part of the grant that we received was with the recognition that there would be availability for individual consultations. So, anyways, any other questions or? It's a lot. It's a lot to cover, right? It's a lot. All right. I think that's. Anything else? Any other questions? So I think we're good. Well, thank you very much, Darren, and thanks to everybody. Yeah.